everyone for joining.
Okay, you should be able to hear me now.
Yeah, so I'm actually going to turn it over to John, who is the chair of this very important task force. We've lost count how many economic recovery task force calls we've had since the onset of COVID, but I would venture to say it's in the 30s and 40s. So this has been an invaluable tool to connect with our members and keep them updated on various changes, legal updates, human resources, legislative, and so forth. So I will just pass it over to John Vanderveld, who will go over the platform and then turn it over to our presenters. Thank you all for joining.
Well, hello, everybody. I am the California Lodging Industry Association Secretary and Chair of the Economic Recovery Task Force. Great that you've all joined us today. How many do we have on the call?
38 right now.
Oh, good. That's
39.
a nice turnout.
39.
Oh, and we'll get a couple more, I'm sure. We've got great presenters for you today. Joining us are Raj Patel and Kumar Maheshwari, if I'm saying that correctly. Raj is with Insight, and Kumar is with Mahesh Raw Group. And we're going to be talking in a few minutes about information you need to know about ADA website lawsuits. A little different from our conversation last week, which was, or 2 weeks ago, which was about the physical condition of hotels as they apply to ADA regulations. Before we begin, I usually ask Bobby if there's anything going on with legislative issues that affect our members over the last month or so. Bobby, is there any news there?
There is, but I'll save it for the CLIA alert.
Okay.
We have a pretty meaty presentation.
Okay, so read your CLIA alerts. And David Bowman, I don't want to leave you to last because some important deadlines are coming up as far as raising funds for our Dollars for Scholars program and our CLIA scholarship program. So what would you like to tell us about that?
Thank you, John. As most people know, we have a scholarship fund at CLIA, and one of the ways we fund that is we have an online auction every spring of hotel room nights and other items. That auction kicks off next Thursday, March 4th, at the California Lodging Investment Conference, CLIC. It goes for 4 weeks. We've got 113 items now. We'll have 150 easily during the course of the auction. We invite people to participate, hotel owners. We appreciate everybody that's donated so far, the cash donors and the donors that have donated room nights to the auction. It's going to be our biggest auction yet. Given the economic conditions, we've had a hard time raising cash for our scholarship fund this year, so we're really looking for a successful auction. If you can refer people to it, the easiest way to get there is just to go to our website, clia.org, CLIA.org, and you'll find a link to the Bidding for Good website that we use for the auction. So again, thank you everybody that's donated. Those of you that haven't, please consider it. We're just looking for unused room nights, meaning that you make your certificate subject to availability so that nobody's booking their auction rooms on a busy weekend. So I appreciate it that a lot of students, they're going to be graduating into a very uncertain job market. So we want to support them. They are the future of our industry. That's it. Thank you, John.
Well, you all got to meet my cat while David was talking. Dave, how are we doing we've gotten a $5,000 commitment for matching donations from an anonymous donor. How are we doing on that?
Well, we have a very generous donor who has offered to match any cash donations that we get up to $5,000. We have $500 so far. We have another $1,750 on the way, I believe, if that's correct. Chris, you can correct me if I'm wrong. So we're not quite halfway there yet. So we're hoping people will step to the line and double their support of the scholarship program by allowing us to match your donation with a donation from this very generous donor.
Yeah, even if you can just send a couple $100, whatever you can send, we don't want to lose this if we are able to to get the matching donations, that will be a total of $10,000 to help young people who are struggling to complete their education in the lodging industry. And so this is one of CLIA's most successful programs. And I hope that we can get a little more participation in the next week or so to help these young people. Okay, so
One last thing before I go, this is CLIA's 75th anniversary. So the auction is part of that celebration. I just wanted to mention that to everybody. It's quite an accomplishment for an association to be operational for 75 years.
1946, Bobby, maybe we were the California Motel Association 75 years ago, and we have some
Correct,
great.
but it's definitely way before my time.
I was there at that first meeting.
Yeah, I wasn't a concept.
And we have some great pictures from back then, some of the meetings, and it's fun to go back and look at that and see how much our industry has changed in 75 years, and the profile of our owners has changed, profile of our members, but we're still doing what we were doing back 75 years ago, and that's helping hotel owners in all aspects of getting the best return on their investment, whether it's through legislative activity or training resources or events like today. So that brings us to today's speakers. Again, Raj Patel and Kumar Maheshwari. I think we'll start by introducing Raj first and with Insight.com, and he's the CEO. And Raj, tell us a little bit about your organization and how you're helping our owners.
Sure thing. So I've been in the hotel industry pretty much my whole life as well. Many of you I've met and seen on the sidelines of the CLIA trade shows, and I'm familiar with you. And for those of you who do not know me, I'm the CEO of Insight. We've actually built a digital marketing platform for hotels. Been doing this work for over a dozen years now. And my background comes from an e-commerce background, was at eBay in the early 2000s, did a lot of strategy work, product work, and been heavily involved with the hotel industry insofar as helping build technologies to, in a lot of ways, liberate hotel owners from the grapple of the tentacles from that you see from the OTAs, the franchises, and kind of the fragmentation of technology out there. So we built a full software technology stack, set of services, tools, and now actually as part of this presentation, one thing that we'll unveil is a program called ADA Shield, which will help hoteliers defend themselves from these type of lawsuits, which we'll be discussing during the course of this presentation. Heavily involved with the hotel industry, so CLIA, CHLA, a whole different other states. Organizations as well. So I'm excited to present this with Kumar, and look forward to speaking to you in a Q&A at the end of the presentation.
Great. So my name is Kumar Maheshwari. I'm actually a computer engineer. So, we understand software, if you will. Okay. Then went on to become a patent attorney. I'm a patent attorney and a trademark attorney, and I was just going right along, and I ran into Insight, and Insight said to me, we're seeing a lot of these ADA lawsuits kind of pop up, okay, and that was about a year and a half ago, and he said, I think you guys are the right guys to kind of, build a defense strategy for this, okay, because the other side, the plaintiff side, is just running a mill and trying to, get little, collections of monies from hoteliers, okay? Especially now, given COVID and the drop in revenue from there, it's even harder for hoteliers, okay? So I think the claim to fame is we achieved a $0 dismissal for a hotel in Southern California against the Manning Group. We'll talk a little bit more about that. It's a plaintiff side lawsuit, law firm. We were defending multiple ADA lawsuits, okay? And I say it's a calling because, 15 years ago when I became an attorney, all I wanted to do was be a patent and trademark attorney, okay? I accomplished that, worked for a large law firm, worked for various different companies, and we're looking forward to educating you guys and helping hoteliers. Thank you.
Awesome. So what I'm going to do is actually, we'll try to keep this interactive. I mean, if anyone has any questions throughout the presentation, feel free. Kumar and I will kind of go back and forth on our presentation. I'm actually jumping over to a Prezi here just to kind of keep things a little bit more fluid and fun. First thing first, we do have a disclaimer here. So this presentation is really for general informational purposes only. It may not reflect the current law in your jurisdiction. We do have an attorney on this presentation, so I think that if there is any legalese that needs to be discussed, I'll heavily rely on Kumar here. The topic of our conversation really is these click-buy lawsuits that have been proliferating over the course of the last several years. I almost feel like Dr. Fauci, and I want to tell you that we're actually on the third wave of these lawsuits. It's almost kind of like if you layer on the number of lawsuits that you've seen, it kind of looks like these COVID cases. So I think that we're kind of in the thick of these, in the third wave of this. And I think that from this conversation and our understanding and knowledge and from our experience of seeing these lawsuits and who's filing them and the legal machinations that they make, I think that we've seen some trends. We know what's going on. There's basically a few serial plaintiffs that are running a mill. And essentially, it's no different than the drive-by lawsuits that were happening, and we've dubbed them the click-buy lawsuits. So how do you protect yourself if you're a hotelier? And how do we collectively as a organization like CLIA or the several other lodging associations that are out there, how do we collectively band together and defeat this scourge, right? So in a lot of ways, I think it's very apt. It's very similar to the crises that are going on right now. And it's really unfortunate that these serial plaintiffs are really attacking the hotel industry at this very vulnerable moment in our industry. So I think what I'd like to say is let's give you all the information that we have, help you as a hotelier defend yourself. And hopefully this is a rallying cry, right? And I think that these are rackets that are being run by these serial plaintiffs. And I think there was that tennis great, John McEnroe, who used to demolish rackets, right? Get angry and just destroy them. So I really think that we all need to get riled up about this, understand the information that we have, and really go out there and defeat these guys. It really is a scourge, and with the right information, the right tools, and the right organization, I think that we could put these click-buy lawsuits to arrest. So what I'm going to do, I think the first thing that comes with this is really understanding the law, right? What's black and white? I think that there's a lot of interesting things that are happening with people's understanding of what is ADA accessibility online. And I think there's a lot of misinformation. People kind of throw around accessibility and the ADA interchangeably. They're actually two different things. So what I want to do is I want to make sure we focus on what is the current law that is stipulated by the DOJ in the Americans with Disabilities Act. So why don't we quickly go through what's black and white and read through it and best ascertain what the law stipulates. So what is the ADA? The Americans with Disabilities Act actually was a landmark law that was signed in by George Herbert Walker Bush in 1990. I think that we could all agree that the spirit of the law is awesome, right? This is what makes America great, right? I mean, the ADA was built around equality for all. And I think everyone here can agree that if you've traveled internationally, if you've been elsewhere where they don't have these laws, this is America at its best, right? The spirit of the law. What is unfortunate is what's happened with different lobbying groups and serial plaintiffs that have kind of really sullied the spirit of the law. And I think for us to understand what we're trying to do as a hotel industry, we have to all realize that, hey, the hotel industry insofar as what we've been through with drive-by lawsuits, all the different aspects of the ADA itself when it comes to physical compliance, we know this law, right? Out of all the different industries out there, in terms of physical compliance, the hotel industry really has pushed the puck forward in terms of making accessibility something that is a secondary thought for the American public. I think we could all agree to that. So what's happened is, I think a lot of these serial plaintiffs, they've exhausted these drive-by lawsuits. and they've shifted their focus to click-buy lawsuits. So the area within the ADA, which really focuses on online presence, is really a small subsection. So let's explore that small subsection. So 1990, the main act goes into play. What ends up happening is there were 5 titles. One of them is the third title, and the third title is called ADA Title III. It prohibits the discrimination on the basis of disability in the activities of places of public accommodations, and this would include hotels and restaurants. So these are dubbed the 2010 regulations. Title III went into effect in 2012. So we're really focused on this subsection of the title when it comes to its applicability to hotels and the hospitality industry. Within that, there are 5 points that really revolve around online accessibility. So this is exactly from the law book, from what the DOJ publishes. And this is very key. All hoteliers must understand this. And this is where the majority or lion's share of these lawsuits are being filed. They're simply taking these 5 points, which I call the 5 points of the ADA Title III. They're taking these 5 points, regurgitating them into a complaint and saying that the hotel is not allowing the plaintiff the free and unfettered access to the property and information about the accessibility features of the property and the ability to book accessible rooms based on the precept of these 5 points. So let's go into these 5 points in detail. Basically, the 5 points ADA Title III are buried in section 36.302E. And within there, it basically states that reservations made by places of lodging must, 1, basically be accessible, right? So your accessible rooms must be accessible online in terms of bookability. A few years ago, a lot of hoteliers that were afraid of broadcasting their actual physical compliance were leery of presenting their accessible rooms online because they didn't want to attract the attention of drive-by lawsuits. Well, the tables have kind of turned. If you don't have your accessible rooms online and bookable, you are clearly in violation of the law. And a majority of these lawsuits revolve around the ability to book that accessible room. So place of lodging must modify its policies, practices, and procedures to ensure that an individual with disabilities can make reservations for an accessible guest room during the same hours, in the same manner as individuals who do not need accessible rooms. And this has to be via all the means and all channels that exist for booking a room online via phone or in person. So this is very clear, black and white. Make sure your accessible rooms are bookable online. Point 2 is really around the transparency of information. And this is where a lot of hotels are failing as well. You need to identify and describe all the accessibility features that your place of lodging offers. And this is at the property level, guest room level, bathroom level. Get in there and really describe as much as you can about the property. And we're seeing some of these suits where they're really taking out the tape measure and saying that we need to know whether or not there's 32 inches of clearance. So explain that, and also explain the details that your property does not have, right? At this point, your physical compliance concerns kind of get thrown out the door because it's so easy for these plaintiffs to really just go online and see you're not adhering to the law here and send you a summons. Points 3, 4, and 5 are really about inventory control, inventory management. And in a lot of ways, these are a black box, but there can be allegations that you're not applying the law here. And what I mean by that is, your PMS is controlling the inventory on the back end. However, one of the key points, which is point 5, I believe, is that the room type that the individual books, they must receive. So if they book an accessible room, you need to make sure that you don't allocate a different room because right then and there, you've been in fault. Point 3 around inventory management is really making sure that accessible guest rooms are held for individuals with disability until all other guest rooms are sold. So this could be controlled by your PMS. Now, there's some interesting dynamics of, hey, what if someone books it online? I think that, and they don't need it. I think at that point, you've honored your commitment to this point. So as long as you're allowing it to be bookable online and you're holding back that inventory, not selling it to a walk-in, with the knowledge that it's an accessible room, I think you're satisfying position number 3.
So one thing I wanted to point out here was when Raj says, it's a black box, what he's really saying is points number 1 and 2, they can see on your website, okay? Points number 3, 4, and 5 are internal controls, okay? So if a lawsuit, let's say, begins and they find out that there's a violation of points 3, 4, and 5 through discovery, then those get tagged. So taking care of points 1 and 2 is essential to not get tagged. And what we've seen, unfortunately, is even when websites go ahead and take care of this and hoteliers go ahead and take care of points 1 and 2, we are still seeing lawsuits because there's no sort of reasoning behind filing the lawsuit. It's just, you're a hotel, we're going to file. Today, we're covering the city of San Francisco. Tomorrow, we're going to go after LA, things like that. So please continue, Rich.
Yeah, and it is very easy for individuals to sit in front of their computer, pay some paralegals, and mill this, right? They are milling this. It's in my opinion, a racket, right? And I think that some of these things need to percolate up to the leadership of government. There was a House resolution passed a few years ago, I think, for at least having a notice to cure period for the ADA. I think it got killed in the Senate. This is all federal, right? This is the ADA, and it's all federal law. So I know that there has been some effort in the past, but I think that everyone needs to coalesce around this and really try to get some common sense understanding of how to combat this through the government. But going back to the presentation, in terms of inventory control, as I had mentioned, you need to make sure that that inventory is removed from sites once it's booked. And then 5, the most important thing is making sure that the guarantee of that accessible room is undertaken upon check-in. So these are really simple, right? It's pretty clear, right? There's 5 points and they're laid out, they're black and white. So these serial plaintiffs, they're really taking those 5 points, and you see these summons, they're just throwing the kitchen sink at you. And there's a subset of hotels, and I would say 80% of them don't know what the hell they're doing. They don't know ADA accessibility or web accessibility. They're relying on website design companies, agencies, or Wix, or doing it themselves, and that is the wrong way to go. And that's why we built a full platform. So what we have is software stack, and within that software stack, we basically can even pull back forensic information about whether or not these attorneys, when they make these claims, they can even be defended. And that's what ADA Shield is about. And we'll get into some of the details of the technical implementation of that in the future. But I do caution you, if you're using a website design agency that says your website's accessible, they probably are making a false claim, because there's a lot involved with this. And as we kind of peel back the layers, you'll see that this requires software. This requires a robust understanding of the law and really a technical implementation. But there is one key thing here is your webmaster, the web designer, digital marketing company, OTAs, franchises, they're not liable. This is the hotel's responsibility. And I'll let Kumar talk to that.
Absolutely. So, as the owner, the hotelier is liable. The digital marketing service provider, the OTA, they're not going to be held responsible, because just like the physical site, that's it. And so in the one case that we, were successful, we told the plaintiffs' attorneys, we've got the records, okay? We've got the back-end accessibility information. And so really partnering with your website provider, and your website provider really providing and backing and the data is really necessary. A lot of times, not all website providers are tracking the back end or the data. And so, in that one particular case, Insight was able to say, well, that, accessibility room was booked 32 times during that period of time. Well, that's actual use that we're able to back with facts, which makes, see, these are like fly-by-night operations or whatever they are. I mean, frankly, it's despicable that they're doing this to my profession, right? But once they find out that it's going to be challenging to fight us, because we're going to continue to fight because we believe that our clients are compliant, they basically back down, because they've got the next, there's another 100 hotels to go hit.
Yep. So I think the key thing though here is we need to kind of jump into where things heading, right? So what I discussed was kind of the black and the white, right? That's been in the law books for almost 10 years now. ADA Title III is very clear, and all hotels must adhere to that. And that's where a majority of the lawsuits are currently. But there is something lurking under that water. What we were really talking about is kind of the tip of the iceberg. And where things are heading are really interesting right now. And in order to understand that, we kind of have to look at case law. And we have to look at case law, and we have to kind of see where different judgments have been made and what's been adjudicated. So the first case we'll talk about is the National Federal Blind versus H&R Block. So there was a complaint alleged that H&R Block, the tax provider, tax company, they have a substantial amount of technology. They failed to code their website in a manner that would make it accessible to someone that has a vision, hearing, or physical disability. So at this point, the DOJ filed a consent decree, and under this consent decree, basically they forced H&R Block to make sure that their technologies conform to what is called the WCAG, or Website Content Accessibility Guidelines 2.0 Level 2A compliance standards. And I will get into some of that and define what that means. But what I want to demonstrate to you is this is where things are heading. There are compliance standards for web accessibility, and this is more so around the ability for individuals that have audio, visual impairment, mobility impairment. And this is completely different than what is stipulated by the ADA, Title III for public accommodations. This is what is called web accessibility. And this applies to all websites. And what you're going to start seeing is you have seen it, that all types of vendors, all types of businesses are being hit by it. And we have seen some of these cases for hotels as well. The next case that trends to this is the big one. This is the Whopper, and I'll let Kumar talk about it because there's some interesting things that we've done versus this law group.
So this is the Manning Law Group, okay? They basically are the ones that initiated this whole thing, okay? So Robles, who was blind, claimed that Domino's website and mobile app, and I want you to pay attention to the mobile apps here, okay? Because right now, all we're seeing is websites. I think the future trend of this, once the websites are all good and everybody's complied, I think the mobile apps is where this is headed, okay? Mobile apps could not be accessed by persons who are blind or of low vision. The judge, and the district court judge, sided with Domino's, the due process argument, and dismissed the case, okay? The court noted that it is for Congress, the Attorney General, and the DOJ to take action to set minimum web accessibility standards for the benefit of the disabled community, those subject to Title III and judiciary. The Ninth Circuit, God bless it, it comes up with great case law, went ahead and reversed, okay, and said that, and remanded to the district court and said, look, Domino's must conform its website, okay? And this is what led to the rest of, the industry, the hotel industry and the restaurant industry getting, sued. The Supreme Court decided they denied the petition from Domino's. So now this is law, okay? The problem is, as you'll notice, the standards are not very clear, okay? So right now what's happening is the district courts are figuring out what does the standard mean. And there is some light at the end of this tunnel, or at least a little bit of light at the end of this tunnel. Some district court judges, even as recently as last week, basically dismissed cases by the new Manning Law Group, which is the Potter Handy Group, or the Center for Disability Rights is what they like to call themselves. And they're starting to dismiss these cases from the get-go, okay? And this is the playbook that we want to deploy and help, our hotelier clients with. Next slide.
So one key thing is, if you look at the timing, I believe the Supreme Court decided not to hear this case in October of 2019. I might be mistaken, but you see that peak of all these cases really started taking off after that. Very similar to these charts here everyone's getting used to seeing nowadays. I might be mistaken, but is that right, Kumar?
Yeah, that sounds good.
All right, and then there's another case that's landmark as well in this space, and this is Gill versus Winn-Dixie. Winn-Dixie is a supermarket company in Florida or in the Southeast, and again, it was around making sure that their technologies adhere to WCAG standards. So I guess that leads us to what's going to be, what is the WCAG, but as Kumar had mentioned, this slide really kind of says that, hey, look, there was expectation that there would be regulations around this, but the Trump administration, which was really against regulation or deregulation, didn't really take any of this up. Let's see what the Biden administration does. But I think the simplest thing is it's safest to be forward looking and achieve WCAG, and then now it's really 2.1. I think a lot of these latest cases are adhering to 2.1 compliance standards. So what does all this mean? So kind of going back to my little motif here, you've got a iceberg. You got ADA Title III at the top, but underneath it is WCAG 2.0, level 2A or WCAG 2.1 standards. So what is this? Website content accessibility guidelines really cover a range of different recommendations for making web content more accessible. You know, following these guidelines make content accessible for a wider range of people. Let's a website that's coded in HTML be digested by a screen reader and other tools that can read out the content audio or present information in a way that's digestible by someone that might have some type of impairment. This is very old as well, actually, in terms of its makeup. And the World Wide Web Consortium is behind this. So the World Wide Web Consortium, for those of you who do not know, is actually a kind of an internal or international quasi-governmental body that regulates the internet. You know, they're behind HTTP protocols, behind domain registration, behind the way servers and things operate. And one of the main things that behind is also these web standards. These web standards are basically called the Website Content Accessibility Guidelines. They were published in 2008. And as technology evolves, technology is ever evolving, right? So you end up seeing that, you know, the newest version of HTML comes out, or you have a different a web layer out there that allows for more fluidity or motion graphics or different things like that. Some of these standards get archaic really quickly and cannot necessarily be met because now all of a sudden you have a different technology standard, and these standards of accessibility get dated and they get clobbered. So you're also finding that some of these claims for WCAG are inaccurate and can be defensible as well if you have a right technology provider that can actually speak to them. But what is W3C? Or what is WCAG? What are these standards? And how do you build your web technologies on them? We'll get into that in a moment. But a key thing here is also that the W3C hasn't developed a certification program. There is no certification program. So if someone says that, hey, you're meeting these standards and I'm a consultant that can guarantee you there's these standards, they're full of it. There's no such thing. So then it kind of goes back towards this ping-ponging that's happening between what is the DOJ really saying, or what are states saying in terms of case law about adhering to these standards when there's really no certification to meet them by the same body that's created them. So there's some interesting ping-ponging going on here as to what is standards and are you really adhering to them. So the thing is really to try to make sure you make an earnest effort to ensure that your website has or meets these standards. There's 61 guidelines that are laid out in this, and they're really around these 4 points that have an acronym called POUR. It's to make your website more perceivable, operable, understandable, and robust. And then different levels are A through AAA, and basically it's kind of like a bell curve. So you want to try to achieve as many as you can of those 61 points within that range in the AA range. And there are some technical implementations here, and this is where you need to have a web designer that's versed in this, understanding of how to code a website to achieve these standards. So what do you need to be compliant? Some simple high-level examples of WCAGs, you know, text meeting minimum contrast ratio, your website being fully navigable by a keyboard, skip navigation buttons, the ability to turn off videos, no flashing lights because it could allow for an epileptic seizure. You know, some of these things are simple, but some can be very complicated. And if you don't have a technical background, you're just trying to slap together a website, hotel website yourself. Again, I caution against that, right? Do not go alone on this. Hotel websites are entirely different beast than other things that other websites or informational website. This is an e-commerce play, right? This is travel commerce, and you need to have a vendor that understands this version of e-commerce. You're not going to trust, for example, credit card processing, inventory control, privacy information to some hokey technology. You need a robust technology that has a cyber policy, knows what they're doing, and is able to defend you in the case of any of these type of complaints. So don't go it alone. So very simply, let's quickly kind of go through how you ensure your hotel can meet ADA Title III concerns and WCAG concerns, and help the defensibility against these suits. Because a lot of these suits, if you're conforming and you could prove you're conforming and compliant, are defensible, right? You're not gonna have to roll over and pay these egregious extortion fees. You should be able to defend yourself. And Kumar will talk about that in ADA Shield and how we've kind of developed this program to help hoteliers with a technology stack and a legal layer above it. So we'll talk about that in a moment. But before I go into that, I kind of want to make sure I highlight what it means to be compliant online. First thing is you need to make sure your hotel's physical plant is compliant, right? It all starts there. First and foremost, you need to ensure that the physical attributes of your hotel meet the standards. And again, this is black and white too, but there are complexities because each building is different, built to different code, different history, and there's a lot of gray areas here too. But I do recommend contacting a CASP to make sure that your website is not your physical plant, sorry, is ADA compliant and you're not liable to a drive-by lawsuit. And as you all saw before, in the last 10 years, pool lifts and accessible bathrooms were major drive-by targets. As I had mentioned before, find a digital marketing system or vendor that has real hotel experience, that understands what they're doing. Address the 5 points of ADA Title III immediately. And as I mentioned, there's two aspects to this, points 1 and 2 around content, right? Robust content. And then points 3, 4, and 5 are around bookability. And one key thing here is also make sure that all your ADA accessible room types are available online on your OTAs as well, right? So you need a good channel manager, CRS, that is managing everything real time. And again, going back to a technology vendor, like for example, we have a full software stack. We have a central reservation system. We are connected to all the major OTAs. So once you have your inventory in our platform, we're able to actually support the compliance with this, right? And present information, data in the case you ever face a lawsuit in terms of defensibility. Now, if you're piecemealing it, you're using one CRS here and one website designer doing this, and you're paying a channel manager, you're gonna really be kind of doing a runaround if you ever run into a problem where you need to defend yourself. So try to find a holistic platform that can handle everything in one place. And this is gonna become increasingly important as technology evolves, especially with privacy concerns. You see hacking going on. You want to have a technology vendor that knows what they're doing when it comes to hotels. So content, bookability, and then the WCAG layer, right? So making sure your web design actually complies to WCAG standards. And then you need to audit all your technologies. As Kumar had mentioned before, it's not just your website. It's if you have any apps. ATMs went through this too. I don't know if you have any ATMs on your sites, on your properties, but ATMs, a lot of ATM vendors came around and updated their software and the kiosk physically as well to make sure that they satisfied ADA concerns. So, TVs, lobbies, all those things are important, right? Making sure that they're compliant. Examples of a web accessible experience and ADA Title III experience, making sure your bookability of an ADA room. And, I don't want to bore you guys with details, but if anyone wants a demo, you could reach out to me. I'm happy to demo what we've done and how we've proven that this in de facto is the standard, right? And Kumar will talk about those details, how we've been able to prove that we built basically the de facto standards for ADA compliance. But basically, you need to make sure you have descriptive and accurate content. We have a content management system that does that automatically. Building a dedicated accessibility page, this is very key as well. ensuring WCAG compliance, so coding it correctly. And then future proofing, right? I think that you need to future proof and make sure that you have a vendor that's continuously ahead of the curve and knowing what's going on. So we call that evergreen technology. We've developed a patent pending solution to help with WCAG. It's an additional layer. It's called ADA tray. We've actually made this very economical, and I think every hotel should put it on their website because it's an additional level of WCAG conformity that it provides, because contrast errors are difficult to control. Contrast errors, again, because of the bridge between, or the gap between WCAG standards and the way HTML is rich now, you have a lot of contrast errors. So you can't have a zero, or it's very difficult to have a zero contrast error website design. And that's where a technology like our ADA tray helps solve that problem and deflect some of the liability from a WCAG standard. So again, we have built this, we've made it very economical. It's $19 a month or something like that to layer onto your website. So I really advise people, if you can't get fully WCAG yourself, and even if you can, layer on this layer, it's additional protection. So do reach out to us if you have questions about that. But basically that allows future proofing, because now as new things come out, we can roll out filters, roll out things to this tray to add additional layer of protection.
Going back to that contrast error, guys, I mean, it's almost impossible, because when you look at a website without ADA tray, right, and it looks completely, when you go to a full contrast error solution, it looks completely black and white. I mean, that's all that's left, okay? But for some people that are disabled in a certain way, that's what they need, okay? And so ADA tray is able to solve that. I mean, I go on to the websites of some of the most large entities. Even they will have contrast errors because they're creating a website for normal visibility, okay? And it's got to be somewhat pleasing, otherwise nobody really wants to use it. But yeah, contrast errors are really hard to come by without having a tool that'll just convert the whole thing into black and white for some people.
Yeah, and again, reach out to us. We've made it. We've made a lot of investment in technology, and even our platform is very economical. My goal with Insight is really to bring innkeepers the tools to kind of take back their margins. And if you talk to any of our clients, they're able to really drive direct bookings and reduce their commissions, because we have a zero commission booking engine and all of it's compliant. So please do at least take a look at what we've done. We've tried to make it democratic and really easy for hotels to get these technologies and be compliant and drive more reservations. One thing that's important here is also ensuring emails and correspondences are also optimized. Another area is PDFs. So if, let's say, you have a PDF, a downloadable PDF on your website, this is another area. PDFs need to be accessible. They need to be able to be read by a screen reader. And that's a matter of how the PDF is coded. I believe Adobe has some tools for that. But again, these are things that people don't think about, right, in your day-to-day business. And it's important to understand that these things are handled, because it just reduces your exposure. And I think going back to the premise of the ADA, it's really about making things accessible to everyone, right? Because it's good for business. All right, so again, integrate accessibility. You need to monitor ongoing accessibility compliance, train your employees, follow the changes in accessibility laws. And I think as this body here, CLIA and hotel owners, I think one thing is we need to make sure we do our job to push how these accessibility laws are actually adjudicated, right? And I think that's what I wanted to bring to the table here, and with Kumar's help, is have a conversation around this. Is how do we as a body help make sure that we have a notice to cure period? I mean, how are these guys able to get away with this without us even having the ability to cure these things, right? It's just, it's common sense, and that these common sense things need to push. And I think Bobby does a lot of work with the state. I think a lot of government aspects of what CLIA does. There needs to be a coalition around these things to fix it. And I think that we can definitely do this and market to the disability community, right? I think that's one easy way to deflect this, right? If you make an earnest effort, then you can really protect yourself from these serial plaintiffs that only have one MO, which is really to extort you for some type of summary judgment. So that's the extent of our presentation here. I'm going to flip back to the last slide that we have for our information here and a thank you. But what I want to do is really open it up for the next 10 minutes. Let Kumar kind of go on his soapbox and explain some of the things, ADA Shield, where things are from a legal perspective, and then open it up to Q&A.
Thanks, Raj.
Kumar
Very,
and
very
Raj.
informative.
Thank you.
Go ahead.
So if we can have Kumar kind of, if you have a few minutes for Kumar, he wanted to kind of run through some of the legal, like the machinations, because I think that's important.
Okay, great. And I'll remind anybody when you have questions to remember to unmute yourself.
Great. Thank you, John. Thanks. Great presentation, Raj. So one thing that gives me hope is that certain judges, for example, there's a case that was cited last week where Arroyo versus JWMFE Anaheim, the suit alleged that the accessibility information provided by a third-party booking website like Expedia was too vague and conclusory, okay? And the district court in this case basically held in favor of the hoteliers and dismissed the case, okay? This was another Potter Handy or Center for Disability Rights case. The court first held that the hotel's not liable for third-party websites, okay? It further held that Expedia site and the hotel website were actually ADA compliant, okay, based on the information on the plaintiff's website. The court listed, a whole bunch of different factors, but, things like identifying all major common areas as website accessible, business center, web wheelchair accessible, the business center, concierge desk, elevator, and you got to say what is accessible and what may not be accessible, okay? Indicates that the routes of travel to areas of the hotel and accessible guest rooms are accessible, specifics that guest rooms are accessible, and provides details on type of accessible features. So when defending against these suits, what I've found really helpful is folks need to take pictures of their accessible rooms, okay, and the accessible bathrooms, because they may be different than the original, the other rooms. A lot of times people can get lazy and put up the same picture, and that really causes a headache, okay, because a picture literally does speak 1,000 words, because I've taken apart pictures, compared a one room picture and compared it to another room picture, and I've said, okay, well, look, this is different and this is different. I've pointed arrows. And so it allows us to defend, some of these folks. And then lastly, what I really liked was a court, and it's Judge Carney in Southern California, that said, for more information about the physical features, here's a special number that you can call to get the information. And Judge really harped on that. So it's happening. It's slow. It's costly too. Which is sad. It's costly for the hotelier to defend in this way, okay, versus somebody who just wants $5,000, $8,000. They file a piece of paper, it's the same piece of paper. In fact, what I'm seeing is I'm actually now having to interact with a paralegal or an attorney located in another country, okay, to defend someplace. So what they're doing is they're cutting their costs significantly and having me trying to interact with, and I don't do that. I just said, look, let's have a U.S. attorney talk to me, okay? I don't need this, okay? I don't need somebody from another country telling me how to interpret the law in California or the law in the United States, okay? So, what we're trying to do is we're trying to set up what's called a reverse mill, okay? And once everyone kind of takes up arms and actually fights and doesn't settle these cases, those attorneys will have to move on to something else, I hope, okay? So that's kind of the spiel here, if you will. Looks like Kabir's got a question.
Can you hear me?
Yes.
Yes.
Okay. So I've noticed on quite a few independent boutique properties, different operators or different webmasters or web management companies have an accessibility page. Some define all the nuances such as height, width, and there are some that just say we're compliant. So is that, in your opinion, what is a better route? Do we define everything to the teeth, or do we just be vague and clear, or be more open-ended by saying that, let's say this guest room has X, Y, and Z, but then not define what the height may be of the counter or what the opening of the door may be, because I know laws every year change and it may be hard to keep up, and so that's a question I have.
I'll let
I
Raj
think-
address it first.
Yeah, I think that's a really great question, right? And so this is where the technology work that we've done really kind of plays its role. We have built a full-on content management solution on our end that supplies and supports all of this information. It's evergreen. So whenever we learn something, we update it, and it updates for all of our clients. And in fact, if you subscribe to that ADA tray product that we've built, you will get that accessibility page that has been proven to defend customers against these very suits. So again, you don't even have to manage it. It's part of this little application that we've built, right? You'll have a hosted page, you'll have a content management system that handles all this, and it's very robust. And you can even actually add custom content in there, and very economical. So again, I recommend more is merrier, right? And you do bring up a point, is how do you manage that? What content do you put? Let us take care of it, because we're actually deciphering these lawsuits, and we're continuously adding this content. So again, I invite you to take a look at what we've built. It's a very economical solution. I think it'll solve it for you,
So is there
and provide effective protection.
is there like a checklist that I check off on your platform saying that I comply with this and I don't comply with this? And
Yep,
then-
exactly. That's what we built.
Okay, and then in addition to that, let's say I may have complied with something 10 years back because that's when the hotel or motel was renovated.
Mhm.
Fast forwarding 10 years, it's not up. The hotel hasn't gone through renovation. So how do you differentiate between what the updated law is versus what was 10 years ago?
Okay, so those points that you bring up it's pretty static, right? What the DOJ did with Title III and the content is it's really derived off of. There's a link on our right here. This ADA.gov H survey. If you click on that link, it'll actually open up the entire book of what the physical compliant constraints are, right? And it's static. It's been there for over 10 years, right? So in terms of physical compliance, those rules are not changing, and there hasn't been anything that's come down the pike saying that, hey, look, now you have to have this type of specification in your bathroom. These things have always been there, and it's just a matter of making sure you physically comply to them. So it's pretty static.
Yeah,
Also,
so on that, I'll second. I think I lost my video, but I'll second that. More detail, the better. Okay, it makes life a heck of a lot easier when you're defending somebody. That, hey, you know what? They actually took the effort to look at the room, measure some things, and then figure out what is and what isn't. Okay, so I think overall my inclination is more detail the better. Pictures, like I said, make life easy. Okay.
Yeah, and I think that one thing we've seen in defending our client against Manning and winning that zero cost judgment was that pictures help, right? So show pictures of accessible features throughout the property, have that documented. And again, going back to the platform perspective, when you have all that data within one software stack and you're able to actually even see different IP addresses or these claims that these attorneys are making that, hey, I visited this website on this date and I tried to do a check availability on this date and no ADA room showed up, we can actually prove that. And that's going to defend you. So you need to make sure your technology provider can do that, right? From a forensic standpoint. And I can tell you right now, once that serial plaintiff knows that they're barking up a tree they don't want to bark up, trust me, they're going to go the other way. And that's really our approach in terms of the shield. Like, hey, guys, you really want to go down this path, because we'll take it, right? And we'll make sure we expose you for the racket that you have, right? And a lot of that is really about making sure you have a robust toolkit and system that protects you against that.
also,
So-
just to jump in, there's a couple of other chat questions for Raj and Kumar, if you can look at your chat button. but this recording can be shared with everyone so that they can look these things up again as well.
So I think there, Carol had a question about having the hotel accessibility being listed. So I could actually show you how we've done it if you will to any one of our websites. I'll pull one up real quick if you don't mind. And this is really the model that we took down the most prominent serial plaintiff. They backed down, right? And they backed down because I think that we've done it right. And we were able to demonstrate things. So most of our clients and their websites, they all have a dedicated accessibility page on the footer, access there. We also have it in the menu, and we detail everything to a T. And again, I think Kabir that had a question about it. All of this is controlled by a content management system, right? So this is an accessibility statement. When you go to the rooms or overview on our overview pages, and they're all designed differently, but the robustness of the content, right? I mean, you see that we've laid out everything and whatever facilities that the property has versus what they don't have. If you go to, let me pull up another one, showing photos. So full on sections of just content, right? Making it clear, put it in their face. You know, it'll custom content. So you're saying, hey, if there's anything that needs to be defined, you show it. On the rooms, I think it's a key thing. Make sure that you show photos, right? Make it indisputable. I think the key thing is to make things indisputable. Let's see if we.
By the way, there's no guarantee even after all this that you're not going to get.
Yeah, there's no guarantee, right? Because, but the thing I think what ends up happening is you get one of these suits, they end up becoming frivolous, right? Because you've adhered to the law. If you could defend yourself, I think that's the key. And Kumar, I think that's kind of the angle that I feel is the safe angle. And I'd love for you to speak to that, but do everything you can do in earnest. So I think the key thing, if you see right here, sorry, my screen is stretched, but showing pictures, because then they can't dispute it. Showing pictures around the path of travel, your access, iconography, right? Just more is better.
Raj, it seems these pictures should also apply to the ancillary services too, shouldn't they? Business center, fitness center, restaurant.
Yeah, exactly. Put as much information as you can. Don't be afraid, right? And I think that was what was happening when the drive-by lawsuits were happening. That customers or hotels were scared to show any pictures because they were scared that people would take those pictures and make a drive-by allegation. So my hope is that everybody's physical plant is actually compliant. So it all starts with that first, right? And making sure that it's compliant or can satisfy the conditions of a drive-by claim, right? Or you could protect yourself or defend yourself against a claim of something, and then take those pictures and show it, right? More is better.
You know, some of our members are bed and breakfast owners, very small inns, just a handful of rooms. And as I recall, the website design ADA compliance topics apply to everybody, including those. There's not a size limit.
Yeah, there's no size.
If you're a place of public.
We lost the audio there.
Kumar, you there?
Can you hear me?
Now we can.
Hello? Okay. Yeah, so, you know, I'm looking forward to seeing what these guys end up doing with Airbnbs. Okay. Because technically it is a place of accommodation. Okay. But Airbnb runs its own, you know, site, and I'm sure Airbnb is also moving towards making sure that their website is compliant and the hotel rooms are compliant.
Yeah, I think that's an interesting space. I mean, I'm surprised that they're not getting slammed because they're clearly in violation of many of these things because they can't control that inventory. But going back to your question, John, about the small properties, I think the key thing for the small properties is really to go through this and understand the physical aspects of what the DOJ has laid out. Make sure they accomplish as much of this as possible. Take this and then demonstrate it online as to what they've been able to achieve. And just like Kumar said before, you want to demonstrate the features, and then also say what they're not, what areas are not accessible, for example, because there's a kind of a gap between what's physically possible and what's not, especially for a lot of these historical properties.
Do you ever have hesitation from owners not wanting to list what's not accessible because they think that might expose them to litigation?
Yeah, all the time. And I think that what we've cautioned them is that I think that err on the side of providing that information and then a disclaimer. So we've actually had some of our clients that have that same exact situation as you speak of, a small bed and breakfast in Napa or down in Pacific Grove or whatnot. These small places are historic, and they don't have the physical, they don't have the ability from a standpoint of whether they're historically chartered or whatnot to make any changes to satisfy some of these wheelchair accessibility aspects. But one other thing that I think ends up happening is there's accessibility for audio visual impairment, which is really the first tier of this, right? And then there's wheelchair accessibility. They're kind of two different things, right? So being accessible, a lot of those components are really about audio visual, braille signage and path of travel that's unobstructed, things like that for audio visual impairment. And I think a lot of the physical compliance falls along those lines. And then the wheelchair compliance, it really kind of has some tiering, right? So if you look at the bathroom requirements, if you go back to the rule book here, and this is why I think a lot of people are confused, right? They think that they must have an accessible parking spot or whatnot if they have a certain size. But if you actually look at the breakdowns in here, it's clear, right? If you have a total number of spaces of 1 to 25, you need one van accessible spot. You don't need a roll-in shower, right? So if you look in here, let's just go to roll in, right? This is why it's really important for everyone to kind of be aware of what the rules actually say. So if you have a smaller property like a bed and breakfast, you need one accessible room. You don't need a shower, a roll-in shower, right? And what is an accessible room? In that accessible room, a lot of those guidelines are around audio visual. It has nothing to do with wheelchair, right? If you read through this, you see right here, it's all about deaf and hard of hearing. And are you providing these amenities? So I really tell all my clients, the first thing to do, I want you to do is print this out, do a self-audit. You don't even need a CASP. And in fact, there's kind of an interesting thing that happens when you get a CASP. So if the CASP comes in and says, hey, you need to do this, and you don't do it, right? Because they're going by a T, they're just going through the same checklist, and you don't do it, now technically you can, be negligent, right? So why not do this internal audit yourself? Try to achieve as much as you can, right? And then make sure you present that online, right? A lot of these things are low-hanging fruits and achievable by every hotel, like buying a TTYL kit or making sure you have braille signage, right? A fire alarm with a strobe. I mean, you go on Amazon and buy all these things, right? And make sure you're satisfying a lot of these conditions. So again, I think the first thing to do is really check your physical compliance, go through the rigor of it, and then take all those things that you've done and broadcast it to protect yourself. Hope that helps.
Who else has a question or comment?
Sal is on the chat. Here's a question for Raj.
Let me pull the chat up.
He's wanting for you to confirm the email. It's probably accessibility@insight.com instead of : accessibility@insight.com.
Yeah, accessibility. And if you go to ADA Shield, I'll just kind of put it in here. You'll see, and then there's an interesting thing here, and this is what we want to share, right? I mean, I know that we've been kind of doing marketing plugging here, and I don't want you guys to feel like, hey, these guys are just trying to do a sell. We've actually done a lot of work, and we've actually made a lot of investment as well in this of our own in terms of the technologies and the legal fight. And if you go to ADA Shield and you go to the legal library, this is the hard work that Kumar and us have done. And the playbook is right there. The key thing is, though, is making sure you're able to defend yourself. The playbook is there, but a lot of people that we see that are getting these cases, they're probably gonna have to roll over and pay it because they're not compliant to what we deem as the standard.
So
But
do
please
you
do
want
go
to
to
go
the
to the
legal
website?
library. Yeah, go to the legal library and you'll see the work we've done.
Yeah, and the reason why we share it is because honestly, we don't want to be in a position to have to defend you. If you can take care of it yourself, more power to you, and I'm more than happy about it. Okay.
So I think that's kind of like our presentation here. You know, hopefully everyone finds it beneficial. And then, like I said, we have a program called ADA Shield that you know, we actually help fight these lawsuits, especially if they're frivolous.
Yeah, I love the expression future proof. That's a great service. That
John, I have a couple of things if I can add.
sure.
So just first of all, thank you to the presenters. At the height of this, we actually had 51 logged in and we just lost some in the last 10 minutes that had to log off. So that's actually excellent. So thank you for your presentation. I do want to call out if Bharat Patel, you're still online, right? Yep, I see you on my screen. I'm going to just do a shout out and see if you could share. I had recommended Mr. Patel to participate in a roundtable discussion on tourism with CalTravel and Visit California with Assemblymember McGuire. And if you don't mind, just, you know, a couple of minutes, if you can share your participation, but thank you for stepping up to lead and be a part of that important discussion.
Thank you very much. Senator Mike McGuire, I think it's SB 240, am I correct? Yeah, is proposed Assembly Bill 240 to allow $45 million to the state of California to Visit California to budget marketing to get travel going again. And the best thing about, one of the good things about it is some of the advertising co-ops have offered to match dollar for dollar so they can stretch that and double the amount. But the main idea is to get travel going. We know airlines and people traveling by air might be a while, but to get Californians traveling within the state and to get tourism jump started. So to help all the lodging industry, restaurants, museums, theme parks, all those things. So if you can, please look up Mike McGuire, Senator Mike McGuire and SB 240 and throw your support. We really need it. There is also, can I throw in another one real quick?
Of course.
Representative Sharon Quirk Silva, along with Senator McGuire, is proposing another bill to move theme parks up a tier for reopening.
Yep.
So reopening earlier. So that will also help the tourism industry. But we're very fortunate. Senator McGuire's taken the lead on this, and any support we can throw his way would be appreciated.
So we will be sending out action alerts through our weekly e-blasts. And I want to thank you, Bharat, because one, your property is, you know, being in Anaheim, you're impacted very directly with not only the theme park reopening, but you're at the heart of a lot of these discussions, like all of our other members. But they really wanted somebody to be part of this roundtable that's seen as a leader in the industry and taking proactive initiatives. So your participation as one of our ambassadors was critical. So thank you for doing that.
Well, thank you for the opportunity.
That's all I have. You're on
Okay.
mute, John.
Anyone else?
Wait,
John?
I didn't hear what John had to say. because he was on
Okay.
mute.
Thanks, Bobby. Thanks again to Raj and Kumar. Excellent topic, excellent speakers. A lot of follow-up for our members there. I think back 10 years ago when hotel owners would tell me, well, my son or daughter just took a website design class in college and they're going to do our hotel website. And it'll really be beautiful. And it's hard to get some people to understand why that doesn't make sense anymore. Wonderful presentation. I want to make sure no one else had any questions. And don't do what I did, forget to unmute yourself. But I will say while we're waiting for any follow-up questions, our next call will be Friday at 1 o'clock, March 12th. Am I correct on that, Bobby? Okay.
Yes.
And any other questions or comments from our participants or our committee members? Well, thank you, everybody, so much. This is another good example why these calls are so important to us. And I look forward to seeing you again in 2 weeks. Thanks, everyone.
Thank you, everyone.
Thank you, John. Thank you, Bobby. Thank you, Kumar. Thank you, Raj.
Thank you, everybody, for having me.